Good morning, Richard Campbell.
Good morning
We have
or afternoon, but yes.
Yes, it is. You're right. It is afternoon here officially. We've started into April now, and it is April 12th, 2023. Thank you again for joining me for a little legal moment page. It was nice to see you for breakfast this morning at our Williamsburg Association of Realtors meeting.
It was a great meeting.
That was a very good meeting. Very good meeting. Lots of great people in there, and certainly welcome your participation in our Realtor Association, and also certainly appreciate your willingness to join here to share wisdom, knowledge to our community here in the greater Williamsburg area. For anybody that wants to know more about how to protect themselves and to prepare for themselves for their own safety protection in liability concerns, as well as planning and estate planning, you are a fantastic resource for all of those kinds of things, in addition to the real estate closings that you do for our clients. So educational opportunities here for anybody that is willing to listen and learn. Richard Campbell has an opportunity to educate us today. So today, Richard, I think since we talked a little bit, a couple times, we've introduced LLCs, we've introduced and spoken about trusts, and then some of the processes under which you would establish these and what they're for. So we kind of covered LLCs and trusts in what you can in a 10 to 15 minute conversation a couple of weeks over the last couple of weeks. Today, I would love it if I could turn it over to you and have you tell us a little bit more about who would need a trust, who might need an LLC, under what circumstances are those kinds of things appropriate, and then maybe even spin into conversations about when might they not be necessary.
Okay.
Are we overthinking that for some people in some cases? And there might be something, might there be something else that they should be thinking of?
Yeah, I think the best way to try to get a hold of it is to first ask the question to potential buyers or current real estate owners. Is it a business? Are you renting the property? Are you using it? You have it and you're using it as a second home, but you also rent it, or you might be Airbnb-ing it. In those type of situations, an LLC is probably going to be the easiest and best bet for someone to just go ahead and try to limit their liability only to the home itself. Basically, you'd create an LLC, call it 123 Main Street, because the property address is 123 Main Street. You adhere to all the corporate formalities, and then your liability would be limited to pretty much the equity for the house that you have an income stream coming. And in that situation, a business entity is 95% going to be better than trying to roll it into a trust, and a will doesn't separate any of the liability at all. So you probably always want to create a business entity if you have enough equity in a piece of property that you're renting or it's income producing. If you are actually occupying the property, or let's just say it's some vacant land that's been running through the family or things like that, then the question becomes, what happens after the death of the owner? And in that situation, there's really 3 different types of protections that Virginia offers through different types of means. So the first and easiest thing is, you own a piece of property and you want a particular child to get the piece of property, or you want a particular nephew or niece or someone who's not a family member. And the simplest way to just accomplish that goal is a transfer on death deed in Virginia, which is very easy. The cost is pretty nominal considering the benefits of having one. And basically you just draft up a deed. It's called a transfer on death deed. And you basically word it almost like a deed of gift. And you just say, hey, I own this property, and when I pass, I would like my son, Stephen, to receive the property. And that clause is kind of ambulatory, which means I can decide today that I'm going to do a transfer on death deed and list Steve as the beneficiary. And if I die, then Steven owns the property. It doesn't have to go through probate or anything. Basically, you just get a copy of the death certificate and you're the owner. Well, Steve is the owner of the property if I pass. So that's just simple, easy way to do it. You can rest easy knowing that that one particular piece of property is going to go to whoever you want it to go to. Then you get into a will. Now, a will gives you no discretion after the death of the testator, and the testator is the person who the will is for their benefit, and they're considered the testator. And then you would put in the will, I want Steve to get 123 North Main Street. And then if you die, the will goes to probate and then gets recorded at the courthouse. And then Stephen would own 123 Main Street because in the will, I said Stephen should have 123 Main Street. Now, the will isn't going to offer any sort of liability protections while I'm still living, but at least I know that Stephen's going to get 123 Main Street, as opposed to my 2 children or my wife, which they'd be very angry at. But yeah, but we're using the hypothetical Steve.
Okay.
In ordinary situations, everyone should have a will. I mean, a will says what you want to happen to the property. And if you don't have a will, then basically you're letting the state decide what they think should happen to your assets. And 95% of the time, the assets are going to go to where you would have probably wanted them to go anyway, if you want them to go to a family member, because basically the way the intestate statutes work, which is when someone dies without a will, it says, well, it goes to your husband or your wife. And then if your husband or your wife don't survive you, then it goes to your children. And then if your children don't survive you, then it goes to your parents. And then if your parents don't survive you, it goes to your brothers and sisters. And if your brothers and sisters don't survive you, then it goes to your grandparents on the paternal side, then the maternal side, then cousins. And basically, the state does its best at trying to figure out someone in some sort of blood relationship that should get the property if you die and you don't have a will. However, if in any way, shape, or form you don't want the immediate family to have the property, then a will is pretty much your answer. Because that, like, hey, I provided my 2 children all of their college. I bought their first house. So I want whatever real estate I own to go to my niece or my nephew, because my children are doing great, but my niece or my nephew may not be, and I want to help get them a jump start on life. So that's why you would have a will. So you could say, I don't want it to go to the immediate people that the state says. I want it to go to somebody just a little bit different.
Okay.
As far as cost and who a will is mostly for, wills are not very expensive, especially considering how important they are. It's probably less than most people's car payment each month to get a will. So with a little bit of budgeting, it's not that difficult to get a will. Now, when you want to complicate things because they need to be complicated, then comes into effect trust. So a trust, the way I like to explain it to my clients, is a will, you die, there's no discretion. An executor or an executrix says, this is what it says in the will, this is what I must do. There's a commissioner of accounts that works at the locality to make sure that what it says that's supposed to happen and what actually happens, and it's done. A trust is more for, you want to either protect your assets from current liability. So you could put it in a trust to kind of get the same benefits of an LLC. Plus, it also allows you to kind of hide, not really hide, but make sure that, you know, everyone in the community doesn't understand all the assets you have. Because if you go through a probate, you have to report it and you've got to put in reports and everything else. If it's in a trust, it avoids probate. Therefore, the state can't say, oh, we're going to disclose all the different assets that were sitting in this trust. So for one, it gives a lot of anonymity. The second benefit is it gives discretion after the trust settler passes. The trust settler is who creates the trust.
Okay.
So if I have a trust, it's the Richard Campbell Trust, I would be the settler because I created the trust. I would make myself the trustee of the trust because I want to be able to control it while I'm still living. And then I would have a successor trustee, which would most likely be my wife. And then my wife would be in charge of all of our assets after I passed. And then she would have the discretion to disperse some of the money to my children or not disperse some of the money to my children. That really comes in handy when you have disabled members of your family. If you have family members that may have drug problems or financial problems, then you really want to put it in a trust, because a trust has a thing called a spendthrift provision if it's drafted correctly. And a spendthrift provision protects the beneficiary of a trust from having any of their assets taken by any of their creditors. So basically, if I'm Bank of America and you owe me $100,000, but your father died and left you $1 million worth of property, then they could just attach the judgment to the property and they're going to get their 100,000 when you go to sell. However, if the land was in a trust and through estate planning they used the trust, then Bank of America can't come into the corpus of the trust, which is all the money sitting in it. They can't touch any of it because there's a spendthrift provision that says no creditor can come in here and take any of this money while it's sitting in this trust. We can just cut off any disbursements, or they could just do straight cash disbursements. Like the trustee could take the beneficiary and go to the bank and say, here's $2,000, without actually putting it in the beneficiary's account, which would subject it to being garnished if they actually owed money to someone. So a trust protects all the craziness. So basically, you've got LLC, really simple. If you have investment property, you probably need an LLC to avoid liability if you have any equity. Then you have a will, which is, hey, I just want this person to get it when I pass. And then you have a trust, which can be as complicated as you want. I mean, you could put in there, I've put in trust documents before that beneficiaries had to pass drug tests to receive money from the trustee of the trust, because the parents knew that the child had a drug problem and they don't want to keep giving out money to someone who's just going to go blow it on drugs. So you can pretty much have any control you want after you pass with a trust. The problem with a trust is they're more costly than a will. You're probably looking at least double, if not triple the price. And it all comes down to how complicated the trust could possibly be. And I don't even want to endeavor to just throw out numbers, but I would say if a will is like 1 car payment, I would say a trust is like 3 car payments. So if you put it in terms of that, you can kind of understand how much the cost is going to be. The majority of the people I meet really just go with wills because there's no tax benefits to actually putting it in a trust. However, if you have more than $6 million after this year, you probably want to put everything into a trust because the federal tax limit is decreasing from 12 million to 6 million. So if you die this year, basically, and you have $11.5 million, then no one in your family should owe any federal taxes. However, if you die next year and you're worth $11.5 million, there's a good chance the government's going to tax the 5.5 million above the 6. So if you are a certain type of person, which I would love to have you as a client, that is valued at more than $6 million, you probably are going to need a trust, and you're probably going to want to get one done this year as soon as you can, just in case something terrible was to happen in January or February of next year. But that's kind of an overview of wills, trust, LLCs, and then the transfer on death deed. So the really easy way, transfer on death deed. The little semi-harder way, a will, and then the more complicated and more expensive way, the trust. But if someone wants to do estate planning, but they also want the benefits of avoiding liability like an LLC, then a trust is kind of the Frankenstein of an LLC and a will, because it offers all the protections and the anonymity. So that's the way you kind of have to look at it.
That is a brilliant summation. I love it, Richard, of the circumstances under which these things are appropriate. And I'm glad that you brought it up and kind of presented it that way, because I feel like you did go across the spectrum a bit. And everybody's life has unique endeavors and unique events. People don't generally stumble into and all of a sudden wake up and say, oh, I've got a $6 million estate now, or an 11 million. They don't just wake up to that. However, there's usually intention to getting to that point in life. And I think that the main value I hope we can bring to folks is, failing to plan is planning to fail. And we want to be able to help on everybody that is planning these things to be able to understand the proper ways that at a certain point you reach a threshold where each of these things becomes a lot more sensible to you, and becomes that next phase of your asset protection, and thoughtfully going about these endeavors and taking the right steps. Often it just starts with a phone call, perhaps, to yourself, and kind of broaching that subject matter so that they can certainly understand what their own aspects and needs would be, because everybody's situation is somewhat unique.
Definitely. The one thing, and this doesn't have to do with asset protection and everything else, but the one thing that every client and every person should have is a durable power of attorney. And what a durable power of attorney does is it allows someone to basically act on your behalf as you. But the benefit of a durable power is it doesn't get extinguished if you lose your faculties due to like a stroke or a car accident or Alzheimer's or anything like that. So I always recommend every single person should have a durable power of attorney that appoints someone, whether it be their husband, wife, daughter, son, someone, and then you should have that and then keep it in a safe place so that if God forbid something happens, you can let the agent know, hey, I always am going to have this power of attorney in the top of my closet. If for some reason I'm in a car accident or something and you need to have access to my bank accounts and talking to the financial advisor and talking to the insurance company and filing taxes, the durable power of attorney is right there so that people can go get it and then act on your behalf. That's a no-brainer. And that doesn't 100% have to do with real estate, but I'll put it this way. If you're an older adult and you own a piece of property and you're deciding, I think I'm going to sell it, and you get a ratified contract, and then God forbid you're in a car accident or something happens,
Life happens.
You lose the ability to sign the documents because you no longer have your faculties. If you do not have a durable power of attorney that's already been signed and already taken care of, you will have to go, someone, most likely an attorney, will have to go through the courts to get a guardian and a conservator appointed for that adult just to be able to sell the piece of property. And then depending on how much the judge wants to be involved, the judge could appoint a guardian ad litem to make sure that the contract was really agreed to by the person who's now lost their faculties. They could appoint a commissioner of accounts to verify that the contract is actually like legitimate and the sales price is correct. And the commissioner of accounts could appoint a realtor who also gets an additional commission beside the commission that you already agreed to in the listing agreement to verify. So basically you're putting it in the full state's hands.
Wow.
If you do not have a durable power of attorney and you lose your faculties during the closing process. So everyone should have a power of attorney, like no matter what. That's the no-brainer. Everyone should have one. And if you are going to get one, if you're not going to call me, make sure that you at least contact an attorney because I can't tell you how many times I've had to fix problems where people go online and get a free power of attorney, but it doesn't meet the requirements of a Virginia power of attorney, or it gives powers that they didn't want to give, or it takes away powers that the people now need. Just contact a lawyer and have it drafted correctly so there isn't a problem. And whatever you do, don't just buy one of those form powers of attorney that they sell at like Office Max. They have like a little section where they sell pre-made forms. I've never understood the people that would buy those. Like,
Yeah,
that's a little weird.
I've seen, I was in there a couple weeks ago and I saw that and I was kind of scratching my head as to just who would necessarily, feel like that's a great way to go. Penny wise and pound foolish,
Well, I mean, if you're going to go that route, why are you even spending the $50 on the 3 pages that they're giving you? You might as well just Google it and throw your hand to fate. But in reality, you're looking at between, depending on how complicated the power of attorney is. Mine is the one that I typically use is 18 pages long, gives every power known to man within it. And my clients typically are looking at between 200 or 300 for a durable power of attorney to sometimes 400 if they have special requirements, but it's not that much. I think
that's not,
I think people just get scared. They hear a lawyer and they think that all of a sudden the forms cost 100 times more than what they see over at, Office Max. And that's not really the case,
Yeah. I'm so glad that you brought that up. And it's obviously each person's situation is a little bit unique. So we're not trying to boilerplate everything across the board, but I appreciate that you brought in some numbers to help people understand that, this is a significant occurrence and you want to make sure that you're protected correctly under all these circumstances, and don't fret over a $200 bill that can protect thousands of dollars of liabilities and protections and hundreds of thousands of dollars in many cases when we talk about real estate. So,
well, and I guess the last thing I would say, if you're asking yourself, should you be paying 300 or 400 to get a power of attorney, or 500 or 600 for a will, or 1,000 or 1,500 for a trust? Ask yourself, how much do you pay a month on car insurance and homeowners insurance? And those things are just to protect the bank that you probably borrowed the money from to buy the car or the house. It's not even really helping you, except you're building a little bit of equity in the car or the house. Having a will gives you the peace of mind and the actual insurance to know what's going to happen to your assets when you die. And if you don't have it, you're basically playing the lottery of what circuit court clerk do you have? What is the current law in Virginia? What's the current federal laws? Who do they think should have all your assets? Yeah. You have no discretion at all if you're not willing to just pay. And for all fairness, you could try to do your own holographic will, which basically means you write the whole thing yourself and sign it yourself. But I'll give you a good example of how that goes wrong. When I first graduated law school, my uncle was like, do I need a will? And I'm like, of course you need a will. And he goes, well, I already drafted my own will. And I said, oh, you drafted your own will? Oh yeah, I drafted my own will. So it's enforceable, so I don't need to deal with it. And I said, well, how did you draft your will? And he said, well, I typed up exactly what I want to happen, and then I signed it. That's unenforceable. That's not a holographic will, because a holographic will has to be in the testator's handwriting, the whole thing. So you can't just type up what you want and sign it. But see, people don't realize, you would think, oh, if they'll just take something with my chicken scratch and my signature, then the state would even like it even better if I actually typed it up and signed it. But in reality, you just killed your whole will because you didn't actually adhere to the formalities of the will. So you just can't. If you try to shortcut the system, it will bite you, and nothing that you actually desired will actually happen. I can say that with full faith. You can try to do it yourself, but unless you're an actual lawyer or know a whole lot about the law, you're probably going to screw something up, and then it might not even be enforceable whatsoever, which would be completely the opposite of what you wanted, because you took the time to try to do it the way you want it.
That speaks so much, Richard, to why I'm so glad we're doing these calls, because we do live in a bit of a do-it-yourself society, and with the last couple of years, people being so resilient about Googling everything and the growth of Amazon and home shopping and all these things. We like to think that we have it all at our fingertips, but the world of legal requirements is so vast, and it pays to have an expert when it comes to these things. I say the same thing about real estate when it comes to protecting this very valuable, probably in most people's lives, the most valuable purchase that they'll ever make, the most significant financial decision of their lifetime often is what piece of real estate they're going to buy or sell. I certainly feel like people should use a real estate agent when they're buying and selling a home, and it brings value. Choose them correctly, choose them wisely. And can you do things yourself? Sure, you can, but under certain circumstances, should you? And in many cases, the answer is no, you really should rely on a professional that really knows their business when it comes to these things. And so with that, I need to let you get on about your day and billing clients so you can pay for your bills and pay for all the things that you have to pay for. And I got to do the same things here. So we will look forward to having another one of these calls, hopefully maybe in a couple weeks. And until then, I'll make sure that you're Richard Campbell here in Williamsburg. Your office is in Williamsburg. You have another law office in Portsmouth as well. You share time between those two locations. You do a lot of real estate closings for us here, but also set up wills, estates, trusts, LLCs. All these things are under your purview, and it is wonderful to have your presence with us this morning. So thank you so much.
No, thank you for the opportunity. Take care.
All right, take care. We'll talk soon. Bye.